Okay, good morning. As you can see, the talk is entitled The Law in the Making and Unmaking of the Kichinbekusi-Bininuwug Struggle for the Right to Say No. This arises from my work. I was in Thunder Bay at the time, and there was a legal conflict, and so I could attend the hearings and get to know some of the people who were involved. This presentation I originally worked on with Dr. David Pirla, who is currently a political advisor to KI. So what I focus on here is the series of court decisions in the dispute between KI and Platinex. The overarching question is what can be learned about the role of law in Aboriginal people's struggles for self-determination and sovereignty from the story of the conflict between KI and Platinex. Okay, now, in focusing on the role of law in the conflict, that shapes the story I tell in a certain way. Okay, law is an institution in Canadian society that reaches many directions, has many functions: policing, resolving disputes, punishing or paying some kind of attention to crime. And almost all of these functions are seen as socially legitimate. And the legitimacy is supported by the state's ability to incarcerate or otherwise punish or exclude those who are categorized as breaking the law or seen as kind of outside the social norms that law establishes. Okay, so in the KI and Platinex dispute, First Nations political organizations, the media, and various social justice and environmental groups also played a role in raising public awareness and in taking positions on KI's struggle for self-determination, basically, and the struggle to assert their jurisdiction. If I focused on those elements of the story, it would change the story. And so it's really important to know that this is only one aspect, that the legal aspect is only one aspect. And I frame this question in a kind of an overall approach that I take to reconciliation, the idea of reconciliation. I see Section 35 as a very promising, a potentially promising approach, which allows something called recognition and affirmation of Aboriginal and treaty rights. Now, Patricia Monteiro-Angus argues that that means we're recognizing and affirming something that's already there. Okay, it's not a grant of rights from the Crown, but it's something that's already there. And so my question is, you know, law, as you've learned in this class, law has imposed many things on First Nations. And so my question is, my sort of overall question is often, you know, what role can law play in reconciliation? Is there any contribution that law can make? So I'm going to begin by describing the community and the background of the legal events, and then turn to the decisions and what can be learned from them. Okay, so Kichinbekusi-Bininuwug, also known as KI, is an Ojibwe Cree First Nation located in Northern Ontario. The community joined Treaty 9 in 1929, and you can see here, Treaty 9, there was a time of signing that was in the summer of 1905, where all the communities in the darker shading were visited, and then the adhesion was made in 1929, and you can see that Treaty 9 takes up over half of the landmass of Ontario. Okay, the community is way up there on the northern shores of Big Trout Lake. That's 600 kilometers northwest of Thunder Bay. Most of the year you can only get to the community by air, and for a short period in the winter you can get there over the ice roads. Now Platinex is a junior mining company which held Ontario-issued mining claims and leases on Nemigwissibins Lake, which lies within KI's traditional territory. It's one of the many small lakes and streams that drain into Big Trout Lake from the south. Nemigwissibins Lake is a culturally and spiritually important area. There are burials in the area, both of people known to living memory and of people from the farther distant past. It's been an historical travel way for First Nations who moved about the area until the time of getting more settled into villages. Okay, so Anyway, so they had these claims staked, and Platinix had the claims staked. And this was an important area for the people, where they still harvested, fished, hunted. So it's a really important exercise of their treaty rights. Okay. In May of 2000, KI filed a treaty land entitlement claim with Ontario and Canada, and that claim was for an amount of land that was not included in the original assignment of reserve lands in the early 1970s. Shortly after filing the TLE claim, KI issued a moratorium on any resource development in its traditional territory. Now, one of the reasons for the moratorium was that when a treaty land entitlement claim is being settled, what usually happens is, if it's agreed to and it's settled, is that the land that's assigned to the reserve lands is taken from the traditional territory. So KI didn't want any of its traditional lands spoiled by mining or whatever to make it sort of useless to include into its reserve lands. The other reason, of course, is the community concern over the potential disruption to the environment by exploration drilling. Okay. Basically, this kind of early exploration work requires cutting a swath through the forest, digging trenches, setting up a drill pad, bringing in lots of heavy equipment and fuel. Okay. Often the fuel drums are just left, and other garbage is just left. Such activity is obviously disturbing to animals and birds, especially at calving time and nesting time. And there's also, it's very noisy work, you can imagine, when they're doing core drills that go 600 meters into the bedrock. Okay. One of the risks of exploration drilling is the contamination to water, both by fuel spills and just in the drilling process itself. Okay. Now the KI community gets its water from Big Trout Lake. It also gets its fish from Big Trout Lake. And it relies on the health of the ecosystem not only for the food, which is important, but also for the ability to continue their traditional ways. Okay? Being out on the land is one of the main ways that the community passes on the knowledge of who they are as a people and what their connection is to their territory to their children. So they want to be able to go out onto the land in order to do that. Okay. Now, in August and November of 2005, the KI leadership sent letters to Platinix explaining that KI strongly opposed exploration. Platinix went ahead and listed on the Toronto Stock Exchange. They did not tell the investing public about these letters, but instead claimed that KI had verbally consented to exploration. In February of 2006, Platinix mobilized a drill team without consent from KI. The chief and council, the elders, community members visited Platinix at their camp and reminded them that they did not have any permission to be on their traditional territory. This was a peaceful action. Platinix, however, hired a private corporate security consultant that then organized the withdrawal of the drill team. Okay. So in April of 2006, Platinix went to court asking for a permanent order to stop KI from interfering with its exploration activities, as well as $10 billion in monetary damages. Now, this extraordinary amount of damages is based on the imaginary amount that Platinix might have made if it had found minerals and if a mine had developed. According to the Ministry of Northern Development and Mines, the chances of this happening on any mining claim are about 1 in 10,000. Okay? So the lawsuit, it's pretty clear that the lawsuit was intended to intimidate and silence the community of KI. Okay. KI then countersued Platinix for damages and an order preventing them from exploring, as well as asking the court to declare that the Mining Act was unconstitutional. Okay. And as you've learned from the line of consultation cases, right, consultation is supposed to happen, consultation accommodation, at least according to the Supreme Court cases, is supposed to happen prior to any development, okay, which would mean prior to early exploration. So the Mining Act is unconstitutional, the argument is, because it doesn't allow for that. Now, something really important to understand in order to see how the conflict develops is there are 3 legal systems that converge on Kitchener-Big-Kusib in Innuwug territory. Okay? The first and most central is KI's traditional law, which arises out of the community's relationship with the land. As KI band members expressed in their affidavits before the court, the land itself, as well as the community's relationship to the land, is sacred. Okay? John Cutfeet, a former band counselor for KI, explains the concept of Kanaweandan Daki. This means to protect and keep the land. This is understood as a sacred duty, and fulfilling this duty is part of community responsibility and identity. For the people of KI, a fuller understanding of Kanaweandan Daki also arises from spending time on the land. Okay, so to be able to go out on the land, to understand it, to hunt and fish, is to understand its connection with the people, okay? And that's part of doing those activities, is part of protecting and preserving the land. The second legal system is the Crown's duty to consult and accommodate Aboriginal groups as soon as it considers any action that might infringe on Aboriginal and treaty rights. This duty arises out of the Supreme Court of Canada's interpretations of Section 35, which, as you all know, states that the existing Aboriginal and treaty rights of Aboriginal peoples are hereby recognized and affirmed. The most significant part of the duty is it should always be exercised towards reconciliation between Canada and Aboriginal peoples, and that the honor of the Crown must be upheld in this process. Okay, they're not supposed to be trying to kind of, you know, avoid the duty to consult or trying to, you know, get into any sharp dealing with First Nations communities. The court expects that meaningful good faith consultation will likely give rise to some adjustment of the government's plans in order to accommodate Aboriginal rights. Okay, and that's why it's really important to have consultation before any plan is put into action. Now, as you also know, most of the Supreme Court cases that interpret Section 35 state that Aboriginal groups do not have a veto over Crown proposals. The no veto idea presupposes then that any Crown action is actually able to accommodate all possible exercises of Aboriginal and treaty rights. Okay, so it assumes that there can always be some adjustment made to the Crown plan to accommodate rights so that the plan can go ahead. I personally think that's a fairly limited view of Section 35. Okay. Now, the third law converging on KI territory is Ontario's Mining Act. At the time of the dispute, the legal interests on which Platinex decided to sue KI arose from the free entry system that's enshrined in the Act. Okay? Now, what the free entry system does is it opens up all Crown land, even that subject to Aboriginal land claims, for staking and prospecting. All a prospector had to do was go out there, stake the claim, and file it with the mining recorder, and then that prospector is not only free to work the land, they are required to do some work in order to maintain their claim. Okay. Now, I will discuss some of the changes to the Mining Act later in the paper, but in 2006, the Mining Act made no mention of Aboriginal or treaty rights beyond a prohibition of staking on reserves. And the Crown's role under the Act at that time was simply to facilitate mining development.